Hi everyone, thanks for joining this Brexit update. I'm Richard May and I'm Associate Director on Osborne Clarke's IP team based in London. Now, obviously Brexit is a big topic and I know many of you have been keeping up with developments. So what I've tried to do is cover the main topics as I see them. And I've got 6 to cover. The first is how rights will be maintained. Then I'll look at renewals and maintenance, registry updates, injunctions, and at the end, because we've had some further clarity in the last few weeks, I'll briefly talk about what ongoing proceedings mean in the context of rights of representation, and then I'll finish on unregistered design right. So that's the agenda. Before I dive into those, I just wanted to set the scene and talk a bit about where we are in the Brexit process and look at the issues from a big picture point of view. So the UK's now left the EU, but we're currently in a transition period. And during this time, pretty much the UK is still within the EU's legal regime. And things are much as they were. Now, that transition period is due to come to an end in 55 days' time on the 31st of December. And it's that day that I'll be referring to as Brexit Day. And we're long past the official deadline by which the EU and UK could have agreed to extend the transition period. So it seems almost certain that the transition period will end at the end of the year. And so that certainly is, I think, what most people are working towards. So that's where we are. Now, what we don't know at this stage is what the precise legal regime is going to be at the end of that transition period. And that's very much dependent on the outcome of the trade negotiations that are going on between the EU and the UK. Now, both sides were aiming for a deal to be done by now, I think, and by the time this webinar goes out, a deal may well have been done, but negotiations could slip well into November. No one really knows. Now, I think there's probably these 3 options, and I'm going to assume that there will be an agreement, some sort of trade deal, even if it's not a comprehensive one. Now, what we do have is a withdrawal agreement, and that's already in place, and that covers how some IP issues will be dealt with. But I think it's important to stress that to a large extent, most IP law is going to be staying the same. The levels of IP protection will be the same, the substantive law, which governs the subsistence of IP rights ownership, validity, infringement, all these sorts of issues are largely going to remain the same. And the reason for this is that most EU law to do with IP rights is going to remain part of UK law, even if there is no trade deal between the UK and EU. And the reason for this is that a lot of EU IP law is already very much embedded in UK law, but also the Brexit legislation that has been put in place. The approach that has been taken is that remaining examples of EU law are retained into UK law. And this is because of this new legal concept of retained EU law that kicks in on Brexit Day, which is where existing EU law is transposed onto the UK statute book, obviously to provide continuity and certainty. So EU regulations, for example, being treated as being part of UK law, and decisions of the Court of Justice, the EU's highest court, have effectively been given the same status as UK Supreme Court decisions. And so these decisions are going to continue to bind lower courts in the UK until such time the UK starts to depart from them, either through legislation or when the Supreme Court decides to depart from them. So we have the withdrawal agreement and other Brexit legislation that give us an idea of what the UK is planning to do. We've also got the EU IPO and the European Commission issuing communication, setting out from their point of view how they will deal with some of the issues as well. So they're sort of the main sources that are covering the topics that I'm going to cover. But we've got to bear in mind, of course, that the trade deal might go further than these, or the EU or the UK might decide unilaterally to put in place their own national rules to provide further protections. So, as I say, that's where we are. Now, I want to move into the topics, and the first is how rights will be maintained for all types of marks, so EU trademarks, but also Madrid designations. Now, hopefully we all know by now that the EU trademark is effectively no longer going to cover the UK, and the UK mark is no longer going to be enforceable at the EU IPO. That's the headline point. But the good news is that the UK IPO and the UK government are committed to ensuring that there is going to be no loss of rights in the UK. So what the UK IPO will do after the transition period expires is to clone all the EU trademark registrations, that's around 2 million or so of them, into UK national registrations without any examination, and that is at no cost to the rights holders. And they will do that automatically on day one, and in the current position, that's obviously the 1st of January next year. So that means no loss of rights and hopefully a smooth transition. Now, I think the point to make here is that while the UK IPO is creating a clone right, what they're not reproducing is the parent mark's case file. So, for example, the UK clone will come over with something like seniority attached to it, but that might not be obvious from the UK IPO record. Or the EU parent mark might be the subject of a challenge or say, a cancellation action. And again, that won't be obvious from the clone mark's record on the UK register. So it'll be important to recognise this new class of clone rights, and hopefully that will be easy, because clone rights will be distinguished. They'll have a prefix UK 009 in front of the current registration number that they've got now at the EU IPO. And in terms of registered designs, it's effectively the same principle. The UK IPO will clone the design registration, provided, as I say, that it is registered at the EU IPO at the end of the transition period. But again, at this stage, I don't think the case file would be reproduced, so recognising a UK design clone will be important. And these will carry a prefix of 900 in front of the existing registration number. So hopefully easily identifiable on the UK register. So what about EU pending applications then? Well, the big difference between EU applications and registrations is that applications are not going to automatically come over. These won't be cloned, but instead rights holders will have a 9-month period to file new UK trademark applications. And they'll take the filing date of the parent EU mark, whenever that may be, which in some cases will date back years or even decades. And I checked the EU register about this, and it looks like the earliest pending EU application was filed in 1997, and it's still under opposition proceedings 23 years later. But either way, under both scenarios of clone rights and 9-month priority periods, the end result is the same. Rights holders will have 2 rights to maintain, which of course means a bigger budget. And also something to bear in mind in that 9-month period is when we try and clear marks in the UK, we're going to need to remember that as well as all the UK trademarks on the UK register, there's still these pending EU trademark applications sitting there, which could potentially come over. And so I think it's going to be very much best practice to continue when you are doing clearance searches, not only to check the UK register, but also check the EU register for this potentially also sort of very large pool of pending applications that could come over and block any new brands. So what about international registrations and IRs that designate the EU in particular? Well, again, what the UK has said is that if the EU designation is registered on Brexit, the UK IPO will clone the mark and create a UK national mark. And I think that's the key point. These will become UK national registrations and come out of the Madrid system. Now, that may come as a surprise to some, because you might think, isn't it logical to keep them within the Madrid system, keep them sitting nicely under the IR instead of creating a standalone UK national registration? Well, that might well be the case, but the UK and the UK IPO have considered this in some detail, but ultimately they've decided it's it is too complicated, and there are some good reasons for that. Now, they've been in consultation with WIPO to determine whether keeping the clone in Madrid is actually a viable option. But because the IPO recognised the obvious benefit of remaining in Madrid, but ultimately, after consulting with WIPO, it was felt that it was too risky to do that, to keep within the Madrid system, and it could actually jeopardise the continuity of protection under the Madrid registrations. And there are various reasons for this, and the main ones are that ultimately the UK IPO needed much more resources, particularly IT resources, to ensure that the transition went smoothly, but perhaps most importantly, that there isn't a clear legal basis under the Madrid system which the UK could rely on. So ultimately, the UK IPO decided that the best way to deliver continuity of protection was to take the UK part of the EU designation out of Madrid and create a UK national right. Now, having said all of that, there is actually a way to get back into the Madrid system under what's known as replacement under Article 4 bis of the Madrid Protocol, and replace the UK clone right with essentially a UK designation, a new UK designation under Madrid. Now, according to WIPO, that's a simple thing to do. You designate the UK under a new or existing IR for the same mark as the clone mark, same spec, same owner, etc. And automatically, the old national right, in this case, that would be the clone mark, that's replaced and continues under the new UK designation. Now, it's also worth filing a TM28, although I understand that's not mandatory. It's worth filing at the UK IPO to avoid any ambiguity. And the idea is that you then allow the clone right to lapse when the time comes. Now, replacement isn't something I've ever done and before. I wouldn't say it's particularly common practice as far as I know, but and I'm not aware of any cases that have tested it. But the headline point is that there is a route back to Madrid if you think the Madrid system is something that you want to continue for the UK right. Now, if the EU designation is pending on exit day, holders will have the same 9-month period from Brexit to apply for UK registration of the mark, keeping the existing priority date. But because it will come out of the Madrid system, it becomes a UK national application, you might not want to bother with that and just subsequently designate the UK under the IR. But you need to bear in mind that the UK designation won't benefit from the filing date of the parent EU designation. It will take its filing date from that day when you designate the EU. So ultimately, what you choose to do really depends on whether you want to stay within Madrid or not, and whether the filing date of the EU parent mark is particularly important. Now, again, it's going to be important to be able to recognise this new class of rights that appear on the UK register, and for this class of cloned right, that the prefix will be UK 008 in front of the existing EU number. And then just very briefly on designs, international designs, the same principles apply. Those that have been filed under the Hague system and designate the EU and that are registered on Brexit Day, they will be cloned, but they will be taken out of the Hague system and they'll become national UK registered designs. And you'll be able to recognise those on the UK register because they will be prefixed with the digit 8. So I also wanted to cover IRs based on EU marks, but only very briefly because I don't really think there's major implications here. Basically, the EU IPO will remain the office of the application for all IRs based on EU marks. They're essentially not impacted. The main thing I think to mention is that UK businesses will no longer be able to base IRs on EU marks unless they have their domicile or a real and effective establishment in the EU. But in reality, obviously, given that basing an IR on an EU mark comes with some inherent risk, I'm not sure this will cause many to sort of rethink their filing strategies. Okay, so moving on to renewals, the Brexit impact really depends on when the EU mark is due for renewal. And there are two scenarios to consider. The first is if the EU renewal is due before Brexit, before the end of the year, once you complete the renewal of the mark, there is no further action. You don't need to consider that any further because the UK clone will be created as a renewed registration. But in contrast, if the EU renewal date is after Brexit in the new year, you'll need to renew both the EU mark and the UK clone. And that's regardless of whether you complete the EU renewal before or after Brexit. So you can try and renew as much as you can now, but in reality, brand owners will need a bigger budget for the additional costs of renewing the UK clone if the renewal falls next year. Okay, so I mean, in terms of maintenance, then one of the questions that is cropping up quite a lot now is what about the EU mark that was cloned? If it happens to be an old mark, over 5 years old, potentially vulnerable to a non-use attack, and it's only ever been used in the EU. Now, the question is, does the clock start again with the clone right, or do I get another 5 years, or do I effectively lose that right because I've not got any use in the UK? Well, the good news is that use in the EU prior to Brexit can be relied upon to maintain the clone UK mark. And equally, the EU has also confirmed the position is the same at the EU IPO. So use in the UK prior to Brexit will count as use of the EU parent mark. Now, I thought it'd be helpful to run through some examples of what this means. And these examples of the UK clone over 5 years old, where use is going to be an issue to maintain that clone. So taking the first example then, use of the mark ceased 10 years ago in 2010. There was only use in Spain and never any use in the UK. Now, under these circumstances, of course, the UK clone can be revoked straight away because it hasn't been used anywhere in the last 5 years. So pretty straightforward one there. Now, the second example, use of the mark stopped 3 years ago in February 2017. And until then, it's only ever been used in France. Been no use in the UK, but that use in France counts because it was prior to Brexit. So the UK clone can't be revoked until February 2022. So that's 5 years after it was last used. Now, the third example, the last use in December, let's say December 2020 this year. In Sweden, so EU use, pre-Brexit, so it all counts. So the UK clone can't be revoked for another 5 years until December 2025. The next example highlights when the use in the EU straddles Brexit, and there's been no use of the mark in the UK at all. Now, the last use of the mark, let's say, is in Sweden in December 2023, but all of the post-Brexit use won't count. So the 2 years post-Brexit use won't count towards maintaining that UK clone. So the clone can be revoked at the same time as the previous example, which is December 2025. And for the last example, there has been use of the UK, of the clone mark in the UK, but that stopped in May 2017, let's say, but carried on in Spain until May 2018. So that use in Spain counts. It's EU use, it's pre-Brexit, so the clock runs from the cessation of use in Spain. So the UK clone can't be revoked until May 2023. Now, as I say, the same principles will apply to maintaining EU trademarks at the EU IPO and use in the UK, which counts if it's before Brexit. Now, moving on to conflicts and pending oppositions and cancellations before the EU IPO. So the rule here is that these will not automatically come over to the UK. So if we take oppositions, first of all, opponents are going to have to keep a lookout to see whether the EU trademark application they're opposing, an equivalent, is filed in the UK, in which case they're then going to have to oppose that, the equivalent UK application. And that will be essentially going right back to square one, starting the dispute all over again. So you can imagine perhaps two UK businesses that have been fighting at the EU IPO, but really the UK market is the important market for them. They might have got quite some way in these proceedings at the EU IPO, but then they're going to have to find that, as far as the UK is concerned, that they're right back at the start again. And when it comes to cancellation actions, similarly, they're not going to be transported over to the UK IPO with the clone mark. Essentially, the clone mark is going to come across unencumbered, but the position is slightly different for cancellation actions, and that's because the UK IPO has said that it will honour the result of the cancelled EU trademark. So EU trademark effectively cancelled. The clone right will suffer in the UK, will suffer the same fate. But there is a proviso here, and that is that the UK IPO won't cancel the clone mark where the grounds for cancellation do not apply in the UK. So grounds for cancellation of the EU mark where they don't apply in the UK. So, for example, something like a non-use cancellation action with literally been no use of the mark anywhere, or if the EU mark is invalid because of confusion with an earlier right that happens to be an everyday English word that will be understood over here, then that will probably, on those grounds, the EU IPO will probably serve to cancel the UK clone here. But what if the earlier right in the EU IPO proceedings is a national mark? Something, so for example, in Germany, and that is the basis of the action, where arguably the linguistic differences could alter the assessment of confusion compared to the UK, then those grounds would probably not apply in the UK, and the result is that the UK clone mark will probably not suffer the same fate as the EU mark and wouldn't be cancelled. So there's a lot. I think there's still a lot of uncertainty about how all of this will work, largely because we don't yet have the UK legislation, so we don't know how these clone marks will be cancelled in practice. There's a question mark over whether the UK IPO will do it automatically, so there's no burden on rights holders to do anything, or will rights holders have to take some active step to make the IPO aware? And is there a sliding scale to that step? Is it just a question of, are we going to be able to write to the IPO and point out the cancellation decision, or will we have to raise new cancellation proceedings in the UK, or will it be somewhere in between? We just don't know at this stage. But ultimately, what I think is worth considering, despite the UK IPO's decision that they will honour the result at EU level, is that you might want to apply to cancel the UK clone straight away in January for other reasons, for strategic reasons, maybe because of the uncertainty about how this all plays out, or because it might take a long time at the EU IPO to get a decision in the EU action. Now, in terms of pending disputes at the EU IPO, I think the main things to highlight is that the EU IPO has made it absolutely clear they will disregard UK rights from day one, from Brexit Day, and that includes pending disputes. So if the dispute is based solely on UK rights, and regardless of the merits, it could be the most clear-cut case of confusing similarity or double identity, the EU IPO will simply dismiss the action for lack of a valid basis, and each party will be ordered to pay their own costs. So the only viable option to carry on the attack against the EU mark is to file a cancellation action before the EU IPO, but that would obviously require you to have an additional prior rights in the EU to rely on. The other option would be to challenge the EU IPO's position to the Court of Justice if the case is a really important case. But as we've seen, and I say that because I think, as we've seen in the past, the position the EU IPO takes is not always consistent with the view of the Court of Justice. Now, in terms of UK disputes, in contrast to the EU IPO's position, the UK won't be discarding EU trademarks in pending actions. So it's effectively taking the opposite position. What the UK IPO has said is that if the dispute is unresolved on Brexit and it's based on an EU mark, the UK IPO will make a decision based on the law as it stands today. So that's good news. Ultimately, you don't have to take any further action or consider a strategy around pending UK disputes that are based on EU marks. Now, finally, on disputes, in terms of marks with a reputation, this is another area where the UK and EU have taken contrasting positions. The UK has said that if a reputation has been created in the EU prior to Brexit, the Clone UK mark will benefit from that reputation. And so presumably evidence from the EU prior to Brexit will be acceptable to the UK IPO in something like a Section 5.3 case. But in contrast, the EU has said that evidence from the UK cannot support a claim to reputation of the EU trademark. That's even if that evidence predates Brexit. So again, I think the practical impact of the EU IPO's position is likely to be the loss of an EU opposition if the reputation of your EU mark is based on evidence from the UK. And so as I've said before, whether that position is ultimately right in law may well be open to a challenge before the Court of Justice for the right case. So moving on to injunctions then, under the current withdrawal agreement, the door will close on the UK court's ability to grant pan-European, pan-EU injunctions. And equally, EU injunctions granted in future after Brexit by EU member states will no longer cover the UK. That's the current position. That's unlikely to change, even with a new trade deal. Now, what about existing injunctions and pending cases? Well, existing EU-wide injunctions will remain in force in the UK and cover the clone mark. But the withdrawal agreement does specifically say that this is subject to any court order to the contrary. So potentially this opens the door to challenge existing EU injunctions. And you can see a situation where, again, say the injunction was secured in Germany, for example, perhaps again because of confusion in Germany, and where, because of linguistic differences, those same grounds of confusion wouldn't naturally apply in the UK. That might be a reason to challenge the existing injunction in the UK. Now, in terms of pending litigation, the question is, what scope of injunctive relief can UK courts grant when sitting as an EU court now, if the case isn't resolved before Brexit? Well, my reading of the withdrawal agreement and the relevant statutory instruments suggests that the UK court can continue to have jurisdiction as an EU trademark court. And what I think that means is that they can grant the usual remedies, which includes EU-wide injunctions. Now, I'd say that's my reading of the withdrawal agreement, but I've seen other commentary and guidance around this, which seems to suggest that remedies in pending cases, trademark cases in the UK, will be limited to the UK clone only if UK court sitting as an EU court. So the position around pending infringement cases in the UK is not entirely clear, but I suspect it's only going to affect a handful of cases, if any, that happen to be pending come the new year. Now, what I wanted to end with is just a few comments about two things: rights of representation and unregistered design rights. Now, both obviously very broad topics, lots of issues and I can't cover all of them. But what I just wanted to say is that on rights of representation, the EU IPO has recently issued a communication that covers this, and it does offer some clarity. Now, I understand CITMA is talking to the EU IPO about some areas of ambiguity in that communication, but for now, I think the main thing to be aware of is that the EU IPO has confirmed that UK representatives can continue to act before the EU IPO in ongoing proceedings, which in my reading basically covers everything that is pending a final decision by the EU IPO or Board of Appeal. So that includes pending applications, pending disputes, including any pending appeals, and generally any pending proceedings that are still live on Brexit Day. And for oppositions, that includes oppositions filed after Brexit, because I think the rationale there is that the opposition relates to a pending application, which comes under the sort of broader umbrella of an ongoing proceeding. And it appears that UK representatives will still be able to act in pending disputes that might come back from the Court of Justice, because, of course, in those sorts of disputes, there will yet to be a final decision issued by the EU IPO, potentially. So it could be many years yet before we see the last UK representatives acting before the EU IPO. And the EU IPO has tried to preempt the sort of questions by saying that this applies, all of this applies regardless if the UK representative has done anything concrete, and regardless of when the UK representative was appointed, provided that it was appointed before Brexit. So he could be appointed in December and still get to carry on. And it even appears that the individual UK practitioner can move firms and continue to stay on the record. But there are two caveats. The first is that this doesn't apply to employee representatives. It only applies to those that qualify as legal practitioners and those that are on the list of professional representatives at the IPO. So any UK business that is represented in ongoing proceedings via an employee representative, and they want to instruct someone from the UK to carry on working on that matter after Brexit, they'll have to appoint a UK-based attorney or UK-based lawyer before the end of the year. So worth checking who is on record as the representative in a particular pending case. And the other caveat is that if the trademark owner is replaced in proceedings, so for example, if the right is assigned away, then the UK representative must stop acting, and the new owner that steps into the proceedings will have to appoint a new EEA representative. And finally, in terms of unregistered design rights, very recently it's been confirmed that the first disclosure of a design in the UK after Brexit will not qualify for EU unregistered design right protection. Now, it was hoped that there would be some reciprocity with unregistered design rights, basically sort of maintaining the status quo. But now it appears that isn't going to happen. So it seems that what's known as the London Fashion Week problem might actually become a reality. So UK designers will have to think very carefully about where they first disclose their designs, because the scope of their unregistered design right will now depend on it. So that's it. There's a lot going on. There's a summary slide of things to consider, but there's obviously lots more to think about, many areas that I haven't covered in this webinar. And CITMA has a great section on its website to help us keep up to date with all of the Brexit developments. And all that's left for me to say is a huge thank you to CITMA for inviting me to speak.